Greetings, listeners, and welcome to the Care Table podcast, dedicated to educating and supporting family caregivers of aging loved ones. I'm your host, Amy Huddleston. Through insightful interviews from both industry experts and family caregivers, we aim to provide valuable perspectives and resources. Let's see who we're learning from today. Hello, welcome to today's episode of the Care Table. This is a very important topic we're going to cover today, which is elder law and estate planning. And I know I'll learn something. I'm hoping you will too. I do ask too that you would subscribe on YouTube to the podcast, leave a review, follow it on Apple, Spotify. Appreciate you being here today. And I now want to welcome our guest, Brendan King, who is an attorney who specializes in elder law. And thanks for being here today.
My pleasure. Thank you, Amy. Yeah.
Super excited to get into this. So let's just start with when we say estate planning, what does this mean? Because I know, I don't have an estate. I don't think most of us have an estate. So tell us, when you think estate.
Yeah. I get that all the time.
Yeah. Okay.
People will say,
what does
my
it
last
mean?
name's not Rockefeller, right? I don't have an estate. I just have some stuff and I want to leave it to people. So estate planning is the broad, comprehensive term that we use for the planning for disability and death. And
okay.
I really encourage clients and anyone to not discount or tune out the concept of estate planning because you don't have great assets or you're not independently wealthy. Estate planning is for everyone, and it is unfortunately that term gets misapplied or misused or misunderstood at the very least for only the very wealthy. That's absolutely not the case. So estate planning for me, for my practice, is disability planning, which includes powers of attorney for healthcare and finance, and then it's death planning. It is wills and trusts and beneficiary designations and all of the things that come with that I'm certain we're going to cover as this conversation continues.
Well, I think that was very important what you just shared. Is so basically you're saying estate planning is appropriate for anyone, regardless of your personal savings, regardless of, your assets, anything like that. We all should be doing this.
100%. I tell clients all the time, they can discount the size of their estate or discount the size of an asset. And I will tell them, if you end up going through probate, it almost costs the same in lawyer fees if you've got a couple $1,000s or a couple $1 million, right? It just hurts worse when you have to pay the lawyer and it takes a bigger percentage or a bigger chunk because your assets are small. So I can almost make the case that the emphasis on smaller estates is more important. Do the planning right so that you're not paying for it on the back end.
So you already referenced the word probate. I wanted to get into that too. But define what that means. What exactly is probate?
Sure. I define it, and I've looked in the Ohio Revised Code for a definition of probate, and there's really not a good one. I define the probate process as the court-controlled process of transferring assets at death. And so maybe that's not perfect, but it works, and I think it's easy enough to understand. It's almost impossible to talk about the probate process without talking about what is a probate asset or what assets are subject to that process. And I always tell clients that an asset that is subject to probate is an asset that's in an individual's name only without a beneficiary on it. So you can avoid probate by making your checking account payable on death to somebody. You can make your car transfer on death. You can make your house. And if you do all of those things, you can avoid probate and get those things to the beneficiaries easier and simpler than going through probate.
Touch on this bank account one, because I just was having a conversation with someone I'm in Rotary with who's a banker, and he said, you really should make your bank accounts payable on death. And I said, well, doesn't every account get set up that way? And he said, no. So when you say that, does that mean I should go into my bank and I need to say to my bank, I need to, what's the term? I need to make this payable on death or transfer?
And I need to make it payable on death. So Amy, if you had an account in your name only, that was without a beneficiary on it. So you have an account that's in your name only, you would go into the bank and say, sit with a banker, right? You don't go up to the counter. You're going to sit with a banker and you're going to say, I want to make this payable on death to my spouse. And if you don't have a spouse, then you make it payable on death to your children or whoever you want your beneficiaries to be. But you spend a moment there with that banker, you might need their social security, the beneficiary's social security number. Some banks need it, some banks don't. But you're going to name somebody as that actual real life beneficiary. And
That's so important.
that gives them no present right in the asset. If you named your account that was in your name only, if you named your spouse as the beneficiary, they can't tell you you're spending too much money. They have no control over the account, nothing like that. It's still entirely your asset. And you can do anything you want with it during your lifetime. But upon your death, that beneficiary designation is a contract between you and the bank that when you pass away, they're going to pay that asset to the named beneficiary.
Why do you think that banks don't do that when you first set up an account?
Yeah, I've wondered that before. I think a lot of us have had accounts. I mean, there's a lot of inertia. Like the bank account that I use is the one I opened when I was 18 years old and went to college, right?
Right.
So it's we don't think about this until we engage in estate planning. If you opened a new account now, uh, I think it's a worthwhile question. Perhaps, and I'm speaking for banks here, but perhaps it can be touchy if they start to get into your estate planning. They're not lawyers, they're bankers. And so maybe they don't want I don't know. To answer your question, I'm just guessing at that point. Yeah, but
I
it's
just
a
think it's
super fair
interesting.
question. Yeah,
Yeah, to
yeah.
say like that just seems like something you should default to asking people who do you want to be your beneficiary. So, and I'm assuming like if you have joint accounts with with like your spouse, it doesn't even like does it not even naturally default to them? If
It
like if
does.
I
Yeah,
passed
yeah.
away, okay. So
Then
then it
your
goes to my
spouse would
husband,
become the
but my
owner.
husband,
Yeah.
okay. So you
Yes,
still though need to do that. You can probably make a second beneficiary like your
you got it.
oldest
Yeah,
child.
yeah.
Okay.
Well, I wouldn't
Okay.
make it the oldest child, and we can talk about that, but I would make it all of your children.
Okay.
We don't want to give everything to one child and assume that they're going to necessarily do the right thing and share it with their siblings. Or this is oftentimes where if there's a trust, that trust is that secondary beneficiary. So husband and wife own it together. The survivor owns it, and then on the death of the surviving spouse, we name the trust as that secondary beneficiary to receive the assets. And I'm
Oh, I
sure we'll
love
cover that
that.
in greater detail as we go on here.
That's great advice. Okay, so let's go back to when we just started to talk about estate planning. How early should somebody start doing this? As far as like coming to you and saying, Brendan, I want to get my ducks in a row and I want to get my estate planned. Like, when should I do that?
It's never too early to do it, I suppose. I had my oldest is 20 years old, and my oldest son is 20 years old, and one of his friends was in last week to take care of his things. There are some special circumstances there, but I had a 20-year-old in last week. And when you think of estate planning, sort of in the big picture, it can and should start. As soon as you start accumulating assets, as soon as you get that first job and start your family and those kind of things, I find that having your first child is the real catalyst to drive people to do this. They think, oh man, this just got real. I gotta grow up and do grown up things now. So that's in a perfect world when it starts. As a practical matter, I have people in their 70s that come to me and they feel like they have to apologize to me, but they say, we've never done this before. And I guess my line, and I'm trying to keep it light, I'll tell them it's not too late until it's too late. So, it doesn't, whenever you get there, we'll get it done. And
We'll
now
get
it's
it
done.
done.
Yeah.
Well, what happens though if you have waited too long? Like what happens if you're in a situation where I'm just going to say let's just hypothetically say like my parents were both in a stage of dementia, confusion, not in their right mental state and they didn't do this. What do I do?
Yeah. It's a mess. And that's not a legal term. It's a mess.
It's a
It-
mess.
the sort of the two things that we deal with are uh, disability and death, right? In estate planning, your powers of attorney are kind of your disability documents in your estate, and if you have a trust, or your death documents. And if you pass away without having done estate planning, the state of Ohio has drafted a will for all of us in the statutes. If it sort of spells out, if I'm married and the spouse is the parent of all of my kids, then everything goes to my spouse. If I'm unmarried and have kids, then it goes equally to the kids. Those kinds of things. It's sort of a bit of a choose your own adventure sort of scheme there that the statutes have written. Uh, the disability planning, though, is where what you're alluding to and where the trouble comes. If somebody receives a dementia diagnosis and gets down the path and hasn't named a power of attorney or an agent to step in and make their financial and healthcare decisions for them, a lot of times the only alternative is a probate court guardianship. And gosh, if we can avoid those, we really want to avoid those. Yeah.
Those aren't fun. They seem like yeah. And you're often just like, it's somebody who you don't even know, right? I mean, you're getting this
It
court
can
appointed.
be. Yeah, it can be.
Okay.
But it also, when they work right and well and when it's productive, a child is the guardian or a spouse or a sibling. It's a family member that's responsible. Then it becomes the guardian. But it's not uncommon that the court's naming somebody or that the guardianship service board is getting involved in those kind of things. So yeah, doing the
But it
proper
sounds,
planning. Yeah,
and just avoid that. Like you want to try to avoid having to go through that guardianship and that heartache. So this is why you want to do the estate planning early, is what you're saying.
100%. Yeah, yeah,
Okay.
yeah, yeah. It's
Okay. So now,
it's
yeah.
it's. I want to belabor this a little bit, but that guardianship, that's as messy as it gets in the law. It's family tension. It's expensive. It's time consuming at a time when you just want to be with that loved one and you just want to help them through this, but you have all the formalities of court and all of those things. It's really something we work hard to avoid.
It's also uncomfortable. I would share, because when I used to own a home care company, we would have situations where, of course, you don't want to know their personal situation, but you can tell it wasn't so pretty, where there were adult children, but yet they had a court appointed guardian for our client who wasn't a child. And you're getting direction from the guardian, you're getting obviously feedback from the kids, and it just is it's very challenging. It's very
Yeah,
challenging to
yeah,
provide great care to that person because of all of these dynamics. So
right.
get these documents in place. Like it's great advice. So let's go back to when you mentioned power of attorney. So
Yes,
you mentioned there's a financial power of attorney and a medical power of attorney.
healthcare power of attorney. Yeah,
Okay.
yeah.
Tell us the difference between those, what they are.
Sure, sure. The difference is uh, pretty fundamental. For the durable financial power of attorney, it allows you to name somebody to step in and handle your finances for you. Generally, when we prepare those, my office prepares those are active immediately. So if I signed one and gave my wife power of attorney, named her as my agent, she would be able to help me this afternoon. If I signed it right now, she could go to the bank and withdraw or make a deposit or do all the things. Now, bear in mind, she's always acting in my best interest as the agent and a power of attorney. So, she can't sell my house without me knowing. I mean, it's got the power to do that, but she'd find trouble if she acted outside of the scope of the document. And the scope of the document is that she always has to act in my best interest. That's the financial power of attorney. It's an incredibly powerful document. So we always emphasize the power that you're giving somebody when you sign that document. And it's super important that you understand it and you trust the person and they're a trustworthy person and they're the right person for you.
That's good advice. Okay. So then
That
how
is the
about
financial power of attorney.
okay.
The healthcare power of attorney is a little bit different. When you sign a healthcare power of attorney, you name somebody to be your agent only when you can't make decisions for yourself. So you're going to make all your own healthcare decisions while you're well and while you're able. But if you lose the ability to make those decisions, you've nominated the person or the people you want to step in and make those decisions for you. And when I look at that document, when I organize that document in my mind, I think of it as kind of giving three groups of power. The first, I go in for a knee surgery and they find something they're not expecting when they open up my knee. I'm under general anesthetic. My wife could give the informed consent to fix what they weren't expecting, right? And then they wake me up and she's back on the bench and I'm back making my own decision. So it's this very temporary scenario.
Okay.
The next one is the prolonged incapacity, probably what your listeners deal more with. An aging parent who can no longer and probably will never be able to make decisions for themselves again. So you name somebody to make those decisions during a prolonged incapacity, during an extended period of time, perhaps leading towards the end of life.
Okay.
The third power that the power of attorney gives is it gives your agent the ability to make end of life decisions for you if you're in a permanent unconscious state or terminal condition. So you have to meet those criteria in the document, and those are met with the assistance or the guidance of a physician, your physician, and a second treating physician. So if you sign only a healthcare power of attorney, if you sign that, you're giving the sort of the very temporary knee surgery scenario power to your agent. You're giving the prolonged incapacity, and you're giving the end of life decision making ability to your agent.
When you reference these, let's say, something urgent could happen, right? Like, so my loved one could have a stroke, they're incapacitated, or like you said, they're having surgery. That makes me think, do I need to like have a copy of this? Like if I'm designated, for instance, as my mom's medical power of attorney, should I have a copy of that?
I think that's sensible. Yeah. Yeah. When people ask that question and we get into this at the end, after everything's been signed, I'll often make an extra copy or two for them to take because they'll have their originals the way I organize things. They'll have their originals in one file. And then I make them the copy and I say, next time you go to your primary care physician, give this to the folks at the front desk and they'll scan them into your file. And then maybe there's somebody that knows more about this than I, but I believe a lot of those healthcare systems talk to each other. So if you have, an Ohio State file, I think some of the other healthcare systems can talk to them, and the same for Ohio Health and Central Ohio Primary Care. If you have your documents with one of those, I believe the other ones sort of can connect and find them.
But it's good advice. So it's like, obviously just ask your doctor to scan it into their system. But I do think it's also wise that you would share it. Um,
100%. Yeah, yeah,
yeah,
yeah. I didn't answer your question as directly as I
no,
should have,
no,
but yeah,
it's well, the
absolutely.
reason I'm going to tell you a story. So I I went over to my parents' house and I said, do you have a financial power of attorney? My mom, her response, are you trying to kill us off? Totally what I'm trying to do, mom.
Yeah.
So first of all, parents are not always going to be open to this conversation. You have to push it, is what I'm going to say there. So I said to her, no, mom, not my intent. I would like to know, though. They both just answered me and said, well, we have a will. So I said, well, you have a will, mom, but like, can you go get it? Like, we need to look at this. So my question to you is if your parents tell you, well, we have a will, am I safe to assume that it includes a financial power of attorney and POA for my medical decisions?
I don't think you're safe to assume that. No,
Okay.
no. I would say that if somebody has a will, odds are they have a healthcare power of attorney, and odds are they have a financial power of attorney, but it certainly isn't 100% of the time. Yeah, definitely
Okay.
not. Yeah.
So it would be good then ask them to go get it, even if they think you're trying to kill them off. Make them go get it out of the
Yeah.
file and look
Yes.
at it and say, and I saw it. They do have a financial power of attorney and I'm designated, had no idea. But it was good that we had that conversation. I could say to them, where are these? What do you have?
I
So I
think the
really want
where
to,
are these part of that is super important too, because if you need that document, it's because things are moving quickly and somebody's become incapacitated. It's a bit of a fire drill to find things sometimes, somebody's in the hospital and Amy's got to act and where's the authority and this and that. So knowing where they are is super important. Even if your parents say, hey, they're in the dresser in the guest room in the top drawer, just knowing where they are,
yes.
I really think that's important. Yeah.
And
Yeah.
making sure that it includes the financial power of attorney and the medical, I think is really important. My question is when we talk about financial power of attorney, you referenced, for instance, like if you had, just signed yours this afternoon, your wife could go to the bank. I'm assuming she has to bring the actual document to show the
Yeah. Yeah.
bank.
Yeah. Yeah.
And then What happens though? Let's say my parents have a financial POA and they pass away. Does it stay in effect after they pass away?
No, that document, there's a more articulate way of saying this, but it dies with them. Yeah.
Okay.
Yeah.
Okay. So that's very important. So
Right.
it ends, which means now let's get into how do I, if the financial POA ends when they pass away and I'm trying to avoid probate, let's talk about like the trust option and what you're talking about to protect those assets to avoid probate. What do I do?
Sure. Sure. You will have you will have drafted the trust. These fictional clients and will have drafted the trust during a period of capacity. The trust can it's a generally, and I'm gonna, without having a client sitting in front of me and knowing all of this, we're going to speak in hypotheticals. So I'm imagining just sort of a run of the mill client that needs what we call a revocable trust. So during their lifetime, this trust is amendable and revocable, revisable, changeable, all of it. They can do whatever they want. This trust, a lot of the planning that I do names a trust agreement as the secondary beneficiary, if you're married, as the secondary beneficiary of your assets. So you and your spouse own things together jointly. On the death of the second spouse to die, assets become payable on death to that trust. And that's the beneficiary designation piece as it relates to the trust. You can absolutely take that trust to the bank and title your accounts in the name of the trust. So you can go there and say the husband and wife trust dated this date becomes the owner of my checking account, and that also avoids probate. Now, I use the transfer on death a little bit more, and this is just a personal preference. This is where the practice of law is an art, not a science, right? But I encourage clients to use the payable on death designation more than titling the accounts in the trust, because there was a period of time when banks, if you took the trust there, they'd say, oh, this is great. We'll close your current account. We'll move all the assets into a new account in the name of the trust. And all of those automatic debits and credits and all of those things that would have to be set up again with the new trust. Right. That's the face I make when I think about all of those that happen in my house, having to set them up. So I think banks are getting better about that. But I think the safest way is to just make it payable on death to the trust, so that during your lifetime, the power of attorney governs that account or can help with that account. And then after you're gone, the trust becomes the automatic owner.
And when you say revocable, like help me understand what's the difference between revocable and I've heard irrevocable
Sure.
trust. What's
A
the difference?
revocable trust is that trust that, whether created by an individual or a couple, can be amended, revised, revoked during either the lifetime of the person who creates it or the people who create it. And then sometimes some of those joint trusts say, if it's jointly created and one of the creators, which we call a grantor or a settlor in Ohio, if one of those people passes away, then the surviving spouse can amend that trust even after their first spouse is gone. So it's the ability to change and revoke and modify, name a new trustee, modify the beneficiaries, whatever that means. That's what the revocable piece is. Now, the irrevocable trust is exactly as it sounds. When you create an irrevocable trust, it is not able to be revised or amended or revoked. That's the general rule there.
Why would I choose one or the other? I mean, it seems like to me I'd want the one that I could amend. Why do
Yeah.
people make irrevocable ones?
Yeah, that's a great question. The irrevocable trust is a tool that is used by estate planning lawyers uh, who are in large part trying to get assets out of an estate. So if you create the irrevocable trust and gift or give assets to it, generally, historically, there are two reasons for that. And I may be missing some here. I don't draft a lot of irrevocable trusts, frankly. One was you'd create an irrevocable trust. You could tie a life insurance policy to it that was owned by that trust, and it could help you pay the federal estate tax when the federal estate tax was something that was much more prevalent and paid than it is today. So kind of an estate planning, estate tax avoidance tool. And then the other one is the much more common is the irrevocable trust is the document or the vehicle that's created to title assets in to get assets out of your estate so that one day you could qualify for Medicaid. A lot of people have a fear that they're going to spend all of their assets and leave nothing to their kids uh, when they are paying for health care. And so the irrevocable trust is a tool that can be used and is used to protect against Medicaid taking all of the assets. Frankly, I don't do that and you and I talked about it. I don't do that Medicaid planning because it is so sophisticated. If you do it, you almost have to do it all the time. The rules are really tight and you just have to live in that world. You can't dip your toe in it as a lawyer. So if I have clients that need that sort of planning, I feel great about the people I refer them to.
And so if somebody is looking for that, so let's say, a listener knows their parents don't have a lot of assets, and that is a concern about eventually qualifying for Medicaid, which means I think is it like 20, it's very little, like 2,500 in assets. Is
Yeah,
that right?
yeah. That's the spend down gets there, but you can keep a residence and sometimes retirement accounts. Again, I hesitate to talk too much about it because I just don't live in that world. Yeah.
But what you're saying is it is worth it for people that they should find an expert. They should find a legal expert that specializes in that Medicaid spend down.
If that's a concern they have, yes, absolutely. And there we have a really good group of lawyers in Columbus that do that work and work really hard. And uh, yeah, I have no hesitations about referring clients to some of these folks because they do a really good job. Yeah.
If I were not in Ohio though, and I'm like, I want to look for one, what's the best term to search online for?
Maybe Medicaid Protection Trust. Sometimes the term elder law, elder lawyer ties to that as well. Uh, I consider myself more of an estate planning lawyer that deals with older clients pretty regularly, but
Hmm.
elder law, I think, is sort of the niche practice name for that.
Okay, so those two would work. Okay, so let's go back now to I'm going to talk about hypothetical situations because I've seen this happen so many times over
Sure.
the years. So, hypothetical situation, I have a loved one who is showing signs of confusion and possible dementia and does not have a financial power of attorney. What do I do?
Well, I think you got to call the lawyer first, right? We've got to sort of gauge the ability of where they are in their dementia journey, right? We've got to figure out if they're early in it, then maybe they still have the capacity to understand what they're signing and sign a power of attorney and avoid some of these things. The other piece that can be real is we've got to have the family buy-in and understanding of what's going on here. So uh, if everybody's on the same page and mom or dad is just received a diagnosis, then we study it hard and think hard about their capacity to sign this document and their ability to sign it. If they get the diagnosis and 3 years later you're getting ready to move them in a home because they can't be cared for in the home any longer, well, that's a different conversation, and that's potentially troublesome, maybe leading to again to that guardianship that we try and avoid. Yeah,
Well, the lesson is again, do this early. Just get
sure,
it taken care of and have it ready.
sure.
So,
Now, let me
okay,
say
so now,
one thing about
yeah,
guardianships as I kind of bang
sure.
on them a little bit, and I don't want you to think that they don't have any utility at all. If you have a family situation where siblings don't get along or don't trust each other, that court oversight of a guardianship, and even in the probate, which we work hard to avoid, the court oversight in a probate estate administration and in a guardianship is incredibly useful. It gives frankly it gives the cover that people need a lot of times if there's distrust. It lays everything out there for everybody to see and it creates a public record and accountability for the guardian and those kind of things. So those are incredibly useful processes, and sometimes even when you have powers of attorney, if the tension bubbles up, you say, you know what, that the probate guardianship is going to be the way to go here. Yeah.
Because they truly are an advocate. I mean, that's the experience that we had when we worked with
Absolutely.
clients who had them.
Yeah.
They were absolutely an advocate for that person. And they have to go through, if they're court appointed and they're not a family member, I mean, they have to go through some, training and screening, and they're
Yeah.
not just somebody they found on the street. So they truly
Definitely
are
not. No.
a
Yeah.
good representative that's going to be a good advocate for someone should you need it in that situation.
Yeah, here in our court
So
in Franklin County, there's been a real they had some trouble, a little bit of a scandal 10 or 15 years ago, and they've really, like you said, increased the training and the need for knowledge of what you're getting into here. So yeah, it's a good thing.
that's very good. Okay, so back to this hypothetical situation we just
Okay.
talked about.
Okay.
Same
Yes.
scenario. I've got a loved one who is showing signs of confusion, and they do have a financial POA. What rights do I have to take over the bank accounts or start doing the bill paying, or, how do I manage that?
Absolutely. So I think that you, with that power of attorney, depending on what powers are granted in the power of attorney, and let's say that it gives you all the powers you would need, right, under this hypothetical, you would want to get a copy in the hands of every entity where the person has assets. So every bank, IRA custodian, financial advisor, all of those kinds of things. You would want to make sure, and you'd want to develop a relationship with somebody there and a contact if possible that says, I'm the power of attorney and I'm going to be acting for them and we're going to, work as a team. That's certainly something that we try and do. And again, get it in the hands of the bank as soon as possible. Because like I alluded to a while ago, when things break on these things are moving fast. And so you don't want it to be, oh, I've got somebody in the hospital that I'm caring for. And at the same time, I'm juggling getting the documents and certifying them to the right entity. So if you get that work done first and it's all locked and loaded early in the process, then when the trouble comes or when you really need it, you're ready to go. Yeah.
I can't agree more with that statement, because we saw so many times over the years that clients would get scammed. They would write checks to, a private caregiver, or, who wanted money. I mean, there are things that are happening when people aren't necessarily in their right mind. And you'd have the adult children say, well, I don't really want to, I want to give them their independence. I don't want to step on their toes. This is their money and their account. But you have to in those situations, because when people especially aren't making the right decisions, if they're having some confusion, it's going to be painful and difficult. But you're right, and you need to take that financial power of attorney document, show up at the bank, start getting involved in seeing their transactions and watching what they're doing, because you're saying you don't have to fully take over, but this would also just allow you to have some oversight of what's going on.
Yes, absolutely. And it would, with the power of attorney, you can ask for duplicate statements. You can do all of those
Okay.
kind of things. So you can, as you say, you don't have to dive in with, head first into this. You can sort of start getting those statements and keeping an eye on your loved one's spending habits and what's normal and what's not. And 1 month, where'd that check go? And you can you can just sort of provide that oversight. And that's useful. That's useful. Get used to their spending habits and understand what they're spending and how they spend.
Completely agree with that advice. Okay, what happens if my loved one has dementia and never named a medical power of attorney? Who is going to make decisions?
Yeah, there is in the hospital system or in the healthcare system kind of a hierarchy created. So there is, it probably parallels our Ohio's statute of descent and distribution, where you say, all right, if you're married, it's generally your spouse, and if you're not, if you have children, it's the children in some order. Certainly, based on, you can tell by this answer that I'm giving, it's not perfect. It's not even close to perfect. And that's where I say, get the documents. Get the documents, and don't let perfect get in the way of great, or whatever the expression is. So
Yes, like, but
name
I mean, this
somebody.
names, it's like, it's just, everything that you're answering to me just keeps going back to the importance of getting this done
Yeah.
when you're healthy, as soon as you have assets, like you said, even if you're in your 20s and you've started to accumulate some assets. So it's just get it done.
Two
Um,
points. 2 points quickly. Let me interject.
yeah.
One, my kids are 20, 18, and 15. And when my 20-year-old's friends turn 18, I'll tell their parents, bring them by the office. They need a healthcare power of attorney because mom and dad can't go into the pediatrician's office any longer and look at the file, or even, I don't even think they can be in the room with them unless the child consents. So, I had a situation, friends of mine, friends of friends, son was away at college. One thing led to another, and maybe he found himself late night in the hospital, and mom couldn't get the answer she wanted. He was fine at the end of the day. But if she'd have had the documents, doors would have opened a heck of a lot quicker. And so I just, for my friends and neighbors and things, I just tell them it's non-negotiable. Stop by the office at this time. You're going to sign this and you're going to name your parents. And you know what? In a perfect world, you put it in the file and you hope you never need it, right? Or you put it in the file and you never need it. But if you do, you just got to have it. So, yeah.
You just reminded me I need to do that.
Well, that
So
wasn't intentional, but very good.
no.
And then
Well,
the,
here's my question though, before you share the second one. What happens if is it specific to the state you live in? Like I have a son who's in Washington and I have
yeah,
a son in Ohio. Like, do you have a different document per
probably
state?
so. Yeah, yeah, yeah.
Okay.
Yeah. Unfortunately for your set of facts, yeah, I'm afraid your son in Washington's power of attorney would look a lot different than, or could look a lot different than your Ohio son's. The other thing to remember with these documents, with the powers of attorney, is as long as you have capacity, they are amendable. So somebody you name as your agent today, if they move to Hawaii, well, they're not the right person any longer, and so name somebody else at that point. And so it's real easy to do that. It's real easy to do that, and folks ought to, with their estate plan documents, sort of be reviewing them or looking at them every couple of years. Not they don't have to sit down with the lawyer, but they should pull them out and they should say, all right, yeah, Amy's still my preferred agent. She still lives around the corner from me. All of those things, and then just know that you're squared away. But I can't tell you over the years how many times clients have brought in real old documents that, oh my gosh, I can't believe I named that person as this or that. I haven't talked to him in 20 years, or, oh, that was our neighbor and we just lost touch, and thinking, oh man, yeah. So,
Let's refresh it. But I do think it's great advice because you never even know. I mean, obviously it's a terrible thought, but if your child did have a horrible accident or something like that, and you weren't named as the medical POA or somebody else, that's not a good situation to be in either.
to be clear, in those cases, those doors open eventually, but what we're interested in is them opening as soon and as quickly as possible, and that's
Yeah.
what we want. Yeah.
Okay. I'm going to
Yeah.
definitely do that for sure. This is a strange question, but I wondered. So if my parent dies with a lot of debt, so credit card debt, loans, whatever, do I inherit that debt if I'm the beneficiary?
Never. No.
Wow. Okay.
And I'm going to give you potentially a fairly long answer on this one because it is an interesting question, real intuitive of you to ask it, frankly. So the debts can only be paid to the extent of the probate assets. The debts collectors can only collect against the probate assets. So if you have a house and a bank account and it all goes through probate and you've got a bunch of credit card debt, then the credit cards will submit claims and get paid back or paid off to the extent of the assets. You sell the house, you create the cash, you put it in a bank account through the probate process, and the credit cards get made whole. What we see sometimes, going back to our desire, our work to avoid probate, is if somebody has those credit cards, but all the assets avoid probate, then there isn't that pot of money for the credit card companies to collect against. So if I'm a single person and my bank account leaves everything to a beneficiary and I rack up great credit card debt, then that credit card company's kind of out of luck because
Wow.
they can, if you avoid probate and no assets go through probate, then you're not. So I have never had, I'm sure there are lawyers that have had, somebody said, well, I just received a terminal diagnosis. How do I avoid all my debts? I've never had anyone come to me and say that. But Yeah, that's a thing. I mean, that's Ohio law is leaves those creditors out in the cold. There are other states that deal with them differently, but Ohio law at this period of time, I have been practicing about a little over 20 years, and I would say for a long time I've said that will change before the end, before my practice close, before I retire. I think that rule will change. But
I
yeah,
mean, I feel bad for them though. I do because like if somebody, decides to go on a spending spree and
right, right.
whatever because they are
Yeah,
terminal and then it's like, oh, too bad. Too bad,
right,
Visa. you're,
right,
you're
right.
SOL.
Yeah,
Okay.
somebody that was real nefarious could have a little fun with that, I suppose. Yeah, I've not
Oh my
had that
gosh.
client. Yeah, I'm sure other lawyers in town have. I have not. So yeah,
So that's an interesting answer. That's not what I expected. So that was
yeah,
like that's
yeah.
really good. What do you recommend? Because boy, I've seen this happen over the years. How do you recommend that somebody would handle a parent who's being financially exploited by uh honestly, I've seen it sometimes by a child. I've seen it, by a neighbor. Um how would, what advice do you give if somebody's sensing that? What's the
So
right thing to do?
going back to our guardianship conversation, there's an emphasis on avoiding a guardianship at all costs, but that's the case where the guardianship works, right? Get somebody in place, make that person accountable to the court, show every dollar in, every dollar out, justify the expenses and the spending, and you cut that off. That financial exploitation can be real, and getting that court oversight in those cases is super helpful and super important. So as I as I was explaining that we try and avoid guardianship, it did dawn on me that there are benefits to that process, and you've just hit on one of them for sure. Yeah,
But that would mean I really should call an attorney first, right? Like I need to call an attorney and say, I need help getting a guardianship
100%.
set up.
Yeah, yeah,
Okay.
yeah, yeah. Mom's
Okay.
caregiver, my other sibling, this or that is taking advantage of the funds for sure. Yeah.
You definitely see that. It's absolutely terrible. Do you have I'm just curious on a personal story. You've been doing this a long time. So if you look back, can you share with us, obviously without names, when the caregiver, like an adult child, for instance, had a really hard time settling the estate because the right documents weren't in place? Can you share something about like a story like that and what had to be done?
Yeah, so that question, settling the estate, speaks to after mom or dad has passed away. Um, I suppose there's a couple of ways to answer that, or a couple of anecdotes you can give, but one of them that jumps to mind is when there's a child or a grandchild or somebody that says, they always wanted me to have this, or they always wanted me to have that, or they said they were going to give me this. And all we can do is look to the documents that are in place, right? And so if grandpa wanted you to have his car or his IRA or his life insurance, then the best way of knowing that, and the only way of knowing that, is did he leave it to you? Did he name you as the beneficiary? So that's a tension that can be created. And frankly, you feel for those kids that were either expecting it or hoping for it or hoping that grandpa, I mean, I don't think people make this stuff up very often. Maybe they do, but when they do, or when they don't, they're hurt by that. You know what I mean?
Mhm.
That's where you say, oh man, I wish if he said that, I wish he would have executed documents that were consistent with what he said, so
So you're basically saying too, I can be specific enough to say, this certain piece of jewelry, for instance, I want left to, you
yeah, yeah,
okay.
yeah.
Yeah, I've never looked at it like that, but I think it's something that you're also recommending to people that if you feel like there's certain things that someone you do want them to have it, put that spe- like specify that in your will.
Absolutely. Give it to him during your lifetime or specify it in your will for sure. Yeah.
Okay. That's
And
that's good.
to that point a little bit, I often think that if you have three, four, two, three, four, whatever kids, the dollars are easy to divide, right? If you have $100 and four kids, everybody gets 25, but
Mhm.
you only have one set of diamond earrings, and mom only had one engagement ring in a lot of cases. So those are the things,
Yeah.
if tension arises, those are the things that I really encourage. If you think there's potential for disagreement, make sure you spell it out. Make sure you identify who you want to have those big ticket items or those desirable items.
I already told my kids, I said, if you ever fight about anything, when dad and I pass away, I will come back and haunt you. Because it
Good.
is
Yeah, yeah, yeah.
because it's like it's completely unnecessary and it's
Right.
just stuff. But I
Yeah.
was very clear with them. I was like, don't even think about
Right.
it because I will come back and haunt you. So,
Yes.
what about like let's talk about I don't know if you have any experience or anybody that's dealt with where they were scammed with maybe funeral, prepaid funeral or um, their burial plans. Have you ever run into that?
A scam related to the funeral or the burial, I can't say that I have. No, no,
Okay.
thankfully. Gosh, that's, it's such a tough time when you're so vulnerable. That feels like a next level scam. You're taking advantage of somebody. Gosh, what a terrible time to take care of somebody. Thankfully, gosh, no, I haven't had
Okay.
that.
It's
Yeah,
just like the scams are so bad right now, though. They're really bad for older
yeah,
people. So it's probably different kinds of scams you're seeing, but I just think that what we talked about earlier is so valuable to just get a second copy of that bank statement or, just to
sure.
oversee it a little bit and be a little bit involved. And if they are prepaying their funeral expenses or they're doing things like that, just just be aware of it. Know that, you feel like everything looks like it's legit and no one is being taken advantage of because it's very prevalent right now. It's unfortunate, but it's very prevalent and it makes me so
That
mad.
would be like a third party service on behalf of the funeral homes or something. And they're not really on behalf of the funeral homes, but they're targeting folks who are in that world and thinking about those things.
Yeah.
Yeah.
It's cruel.
I
Um,
do I do often recommend to clients, after they leave, if they're older, they'll say, "Well, what's next? What do I need to do?" And I said, "When you're ready, and there's no hurry, but when you're ready, go to the funeral home of your choice and you can plan the entire thing and pay nothing. You can plan the entire thing and pay for it all. You can do whatever you want." But I do, going back to the funeral, uh, question, what a gift that is to your family, honestly. And I know it sounds corny to call it a gift, but at the time that they're grieving and all of a sudden they're put, it's laid out in front of them to pick this casket or that vault
yes.
or this song or that, to have it all done for them is truly a gift at that time.
I couldn't agree more with you. I found the other day, I was actually going to a retirement party of somebody who I used to work with in the home care industry. So I knew she wouldn't take offense to me giving her this gift. But I found it in a bookstore and it was a book, like a beautiful book that says on the front, "I'm dead. Now what?" And
I know that book exists. Yeah, what a
it's
title, right?
amazing. Right?
Yeah,
But it's like
yeah,
you and I know that there's so many people that say, "I don't wanna talk about that," or but guess what? We're all going to die. And
yeah.
if you could give that organization and gift to your kids, I just feel like there's nothing better. So there's nothing they have to fight about. There's nothing that they have to wonder about. And if you can put that all in an organized fashion that says, here's where my accounts are, here's the attorney you're going to call, here's my bank, here's my obituary. Like this is what I want you to put in there and, my funeral plans. I mean, what a gift because
No
it's
doubt. Yeah.
it's already a hard time for them and if you already took care of all that, she loved it. So I was like, I'm probably going to get one from my parents. I'm not sure how well my dad will receive it, but I'm definitely my mom, she'll be fine with it. It's good.
Yes.
Um,
Yes.
okay, so I did want to ask you, do you know on the Medicaid front, we talked just a little bit about it. You
Sure. Sure. Sure.
recommended that you find a Medicaid expert, but for people that are slightly concerned about their parents' assets and the amount that they have and whether it's going to be enough for them to survive on, do you have any sense of how that Medicaid there's like that 5-year look back period?
Sure. Sure.
What
I know
what does
just
that mean?
enough to be able to refer them to somebody else. But yeah,
Okay.
so if you gave all your assets to that irrevocable trust today, January 15, 2026, those assets, those assets, that are given to the trust would be able to be clawed back in by Medicaid. They would be what I think they call them includable assets for Medicaid until January 16 of 2031.
Wow.
That
Okay.
that number used to be 3 years, and it's probably been close to 20 years. I think that they've moved it to 5. Yeah. So that goes back to a theme of some of your questions is when do you do this planning? Well, you got to do it early. You can't do it when the dementia diagnosis hits because that's almost. I mean, it's not almost. It is too late in most cases. Yeah.
It's way too late. So I just think what you shared is so essential that I think more than anything you're doing in as you plan to age is this to me is most important to
Sure.
get that estate planning where you've got that financial power of attorney, you have a medical power of attorney, because in all the clients that we cared for, I'm telling you, 50% of them had something physically that was hard for them. So they needed physical assistance, hands on assistance. The other 50% were somehow cognitively impaired. So I feel like we're all going to fall in one of these buckets. And so if you get these documents in place, you're covering your bases. You're covering
Sure.
if I'm going to need some medical decisions made for me, or if I'm not able to make some good decisions with my finances, then I'm going to specify someone that can keep me safe and keep my assets safe. And
Yeah.
that's what we need to do first.
I had a gentleman in yesterday whose father passed away and had a complicated estate and owned a bunch of entities and bank accounts and things like that. And this gentleman, he loved his dad to death. It was his role model, lifelong role model. But gosh, it hurts his dad's legacy with him because the freshest thing in his mind is having to navigate this mess of an estate. And so if dad had just done a little bit of planning, it really, when you use the term legacy, it's not overstating it. It's the last memory you have of your parents in a lot of ways is cleaning up this mess and the months and the hours and all of the time it can take if it's disorganized. So yeah, it really is going back to the idea of broadening the idea that the funeral planning is a gift. All of this planning is a gift, really, to your family.
I couldn't agree more with you. So the last thing I'd ask you is like, as far as what do you think is the best scenario for a family to be in, like in their situation with regards to their long-term planning?
Sure, I think the maybe I'm not going to answer it as specifically because every family's different, but I think you got to have uh, a lawyer that you trust, who knows what they're doing, and can guide you through the process, starting as early as possible. It's a conversation, and these documents. Again, might sound a little bit corny, but they're living, breathing documents. When you name your kids in roles, you have to take into account that they're going to get married and they might move, and you've got to change those documents. And people come in and out of your life, and relationships change, and your documents have to change with them as you age, as your relationships change, all of those things. And there's just really very little harm in preparing the documents and then a few years later, 5 years later, bringing them back to the lawyer and say, just remind me what all of this says. I think sometimes people are too proud to do that, but these are complicated legal documents. I don't expect anybody to know exactly what they say or how they operate after, long after they leave the office. You're not committing this to memory. It's a process. And that's what a good lawyer will do for you. That's what a friendly, appropriate representation, involves, I think. So,
That's very good advice. So to go back and revisit it, which I need to do. So, I mean, as you said too, like your kids get older, they're in a different life situation, and you often can't remember what you put in there. So I think
right.
that's very
So
good.
often, and kind of to that point, so often, I mean, in my practice, my kids are older now, but there was a period of time in my practice where I had many clients that had the baby in the carrier in the conference room as we're talking about. So they're in the fog of war when they're putting this together. I mean, they haven't
Yes.
slept. They're dealing with all the nonsense of having a baby and maybe a little bit older child or another. So to remind people what they say, sometimes they'll say, "Oh my God, what were we thinking?" Or, that kind of thing. Right.
Or you realize, when you've got a 20-year-old, I mean, I have an almost 23-year-old and a 19-year-old, and I think to myself, I'm not ready to give them all of our money. I mean, you have like, if you to me, I'm thinking you got to
Yeah.
have a plan where you could say, okay, they need to get to 30 before they're going to get, because
Yeah, that's
they would
definitely
not
part
make
of the
good
trust
choices.
plan. Yeah,
They would go
yeah,
on a shopping spree. And I'm like, no, no, friends, this is not
right.
what your mom and dad would want you to do. So
And even, and I'm sure your kids are responsible, I'm certain of it, but they, even if they are responsible, you almost do them a favor by delaying it and saying, we'll put it in a trust and your uncle will be the trustee. And when you need something, go to him. But it's one less thing for you to worry about, because remember, we're talking about a scenario where you've lost your mom and your dad, you, you
so
know?
true.
And
Yeah.
so if the less you have to think about, the better at that point, and grieve and do the appropriate grieving to pile on all of the responsibility that comes with this. I don't know. And not a lot of kids, not a lot of 20 somethings or younger are equipped to handle that, I don't think. So,
Zero equipment, zero. That's what I would say. Their brain isn't fully developed, right? I mean,
yeah,
so
yeah,
yeah, give
yeah.
them the gift, get these things in order. And would you just say, like, is there, besides just searching online for an elder law attorney, what would be the best way for anybody, regardless of what state they're in? Is there a website that's good to find, like
Gosh,
a,
if there is, I don't know of it. I got to think
okay,
there is, but I think, a simple estate planning lawyer near me kind of thing is a good way to go. Uh,
okay,
And actually, I'm going to hedge on that a little bit. Maybe the way to do it best is to ask your friends and neighbors, or ask a sibling or somebody you go to church with, whatever your organization is. Say, hey, have you done this, and do you have anybody you can recommend? Because that's pretty nice. Uh,
I
Perhaps
agree.
many of us don't advertise in the traditional sense, and so the word of mouth and having treating clients right is a great way to grow a business.
I think word of mouth is essential. Yeah, because obviously you're getting people that can really really vouch for you, not just finding some results online. So that's helpful. Is there
Right.
anything else you would share to close of just advice or direction or motivation you want to give people to really get
Yeah. So
this
maybe
done?
maybe to that point, or maybe when you find, yeah, I think it can be an intimidating process. I think it can be intimidating to call a lawyer and go to a lawyer's office and sort of bare your financial soul and talk about who you want to be the guardian or the this or that. I would tell you that if you find the right person. Don't be intimidated by the process. There are good lawyers that do this work. We spend we know the questions to ask. We're efficient about it. We can help you through that process in a in an efficient and not intimidating way. But I know there's a meeting a month where they leave and they say, "Oh my gosh, you made this so much easier than I thought it was going to be." And we're professionals. We do this. We can sense that in people, and so there's a lot of good lawyers that do this work, and a lot of good people that do this work. And I would say that if you find a good one, you'll generate a relationship and have that ability to rely on them going forward. So uh, don't I guess the don't be intimidated. It's not all lawyers are in an ivory tower, with find a community lawyer if that's how you're suited. Find a big firm lawyer if that's how you're suited. But find one and develop a relationship with them.
I think that's great. And and just do it. This, like,
Do
you've
it.
got to
Right.
do this. Like, it
Right.
sounds so critical to, you're going to find such peace in having this done, and having an advocate like you on your side to know,
Hopefully.
if
Yeah.
and when that time happens where I pass away, I know my kids have somebody to call, and they've got, everything's taken care of. Like, it's
Right.
just, you are truly giving a gift to your family. So just do it. And I can't thank you enough. This was enormously helpful. I've got a lot of homework myself to do after talking to you.
Sure.
But it's good. You motivated me, and hopefully you're motivating the listeners. And I'm sure I will invite you back sometime if you're open to it.
Of course. Yeah. 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 It's been fun. Yeah. Yeah. It's been
Thank you,
fun.
Brendan.
Yes. No problem.
That's a wrap for today's episode of The Care Table. Thank you so much for joining me. If you found this information helpful, would you like, subscribe, write a review, or share this episode with someone that you feel could benefit from hearing this information? I'd sure appreciate it. If you learned of anything during this podcast as far as books, resources, or products that you might think are helpful, be sure to check out the podcast show notes for links to access that information. A friendly reminder that this is not medical or legal advice. This is just information. Consult a professional for your own personal situation. I ask that God would bless you with the wisdom, the courage, and the strength that you need as you're navigating this caregiving journey. And I want to remind you, you are not alone. I appreciate you joining us today. And until next time, stay strong. And I hope to see you at the care table.